The Caribbean Court of Justice, Appellate Jurisdiction on Appeal from the Court of Appeal of Guyana. CCJ Appeal Number GYCV 2024-001. Hearing of the appeal in the matter, the Attorney General of Guyana, Sarah Brown, Vikash Ramkisoon, against Christoper Jones, and the Speaker of the National Assembly. The members of the panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Anderson, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Burgess, and the Honorable Mr. Justice Jamidar. Counsel, you may now enter your appearances.
Good morning. Should it please the Honorable Court, the Honorable Attorney General of Guyana, Mr. Mohabir Anandala, appears in person, and with him as the learned Solicitor General, Mr. Nigel Hall, and Ms. Shoshana Lal. Mr. Douglas Mendes leads me, Clay Hackett, on behalf of the second and third appellants.
Yes, good morning to you all. Counsel online, are you hearing us?
Yes, please, Your Honor. Good morning.
Good morning. Good morning. Yes, good morning, Your Honors. My name is Selwyn Peters, and I appear with Dr. Dexter Todd, Mr. Darren Wade, Ms. Sasha King, and Senior Counsel Roysdale Ford on behalf of the first name respondent, Christoper Jones.
Morning, Your Honors. Your Honors, I am C.V. Satram, and I appear together with Mr. Mahendra Satram, Mr. Manoj Narayan, Mr. Ron Motilal, and Ms. Chandini Motilal for the Speaker of the National Assembly.
Nanlal, or is it Mr. Mendes?
Good morning, Your Honors.
Yes, good morning.
This appeal concerns the appointment of the second and third appellants as parliamentary secretaries under Article 186 of the Constitution. If I may take you directly to that provision, please.
Mr. Mendes, just for my clarification, you appear for who?
The second and third appellants.
Second and third. Thank you.
They are the persons who were appointed as the parliamentary secretary.
I'm sorry, I'm not hearing you very well, Mr.
Sorry,
Mendes.
they were the persons who were appointed as parliamentary secretaries.
Thank you.
So it's their appointments which are the subject of this appeal. By Article 186, seems as it's coming up a little blurry on the screen. It's my eyesight, I'm not sure. It provides that parliamentary secretaries may be appointed from among persons who are elected members of the National Assembly or are qualified to be elected as such members. So there are two categories of persons who are eligible to be appointed. If I could ask you to look at sub 3 of 186, it says a parliamentary secretary was not an elected member of the Assembly at the time of his or her appointment shall, unless he or she becomes such a member, be a member of the Assembly by virtue of holding the office of Parliamentary Secretary, but shall not vote in the Assembly. Now, it is the case of the appellants who I represent that when they were appointed, they were on a list of candidates, that is to say the PPP civic list of candidates, which had garnered a sufficient number of votes as to win it as an allocation of a majority of the number of seats in Parliament.
Mr. Mendes, from time to time, we may ask you some questions to clarify
Of course.
the nature of the electoral system in Guyana. The first of which is how many members were on that list?
On the PPP civic list,
Yes.
116.
116.
Yes.
Does the Constitution require any particular number of persons to constitute a list?
No, it does not. No, it does. No, it does not.
Okay. And of the 116, how many were extracted? Do you know offhand?
33.
33 were extracted. So the remaining 80 something are unextracted members
On the list.
on the list.
Yes.
Okay.
And the second and third appellants were on the list, but not extracted
Right.
when after the election. So they were not among the 33 persons extracted from the list to be members of the National Assembly.
And just the 30, is it a system where the first, I take it that given the mathematics and so on, 33 members on that list would be members of Parliament, would be,
Well, they, having been extracted, they become the members of the
I just with the
Assembly.
number now.
Yes.
It will be 33.
33, yeah.
Okay. It could be any 33, or is it in 1 to 116 and the first 33
No, it is for the list representative to
to select?
select the persons who are to be extracted from the list.
I
And
see.
that is in accordance with the Representation of
Right.
the People Act.
Okay. Okay, yes, go ahead.
Names are in alphabetical order. So that the second and third appellants were on the list, but they had not yet been extracted. So our case is that they were not elected members of the National Assembly, but they were qualified to be elected as members of the National Assembly, so that they satisfied 1861. And because they were not elected members of the National Assembly, they qualified under 1863 to be, or they were not qualified, they were deemed to be members of the Assembly, but without the right to vote.
Mr. Mendes, what qualifies them?
To be elected,
Yes.
Article 53 of the Constitution deals with qualifications. You will see that at page 588 of the electronic record. And it says, subject to Article 155, which relates to allegiance, insanity, and other matters, a person shall be qualified for election as a member of the National Assembly if, and shall not be so qualified unless he or she is a citizen of Guyana of the age of 18 years or upwards, and B, is able to speak, and unless incapacitated by blindness or the physical cause to read the English language with a degree of proficiency sufficient to enable him or her to take an active part in the proceedings of the Assembly. So as long as you fit those two criteria, then you are qualified to be elected. That is subject to 155, which then contains a list of disqualifications.
Yes,
which I don't think I need to read out.
we know that. This may not be relevant to, germane to this case, but what is your view on the argument that you are not qualified if you are not on the list?
No, you could be qualified to be elected as long as you meet the constitutional criteria to be qualified to be elected to the Assembly.
That's the Article 53 qualification.
That's the Article 53, and as long as you're not disqualified by Article 155.
Yeah,
you
but
are
a person
qualified.
who is not on the list
Yes.
can't be extracted.
They can't be extracted from the list to become a member of the Assembly. So you have to be on the list to be extracted to be in the, as a member of the assembly, but to qualify to be elected, qualify to be put on the list, let's put it that way, as long as you meet the Article 53 or criteria and you're not disqualified by 155, you're qualified to be on a list.
Yeah, it's not relevant to this, it's just an interest in this.
Yes.
But President, if you allow me, just to be clear, is your view that a person could be appointed parliamentary secretary even if they're not on the list, but Article 53 qualification, absent 155 disqualification?
That's correct, because all it says is, all Article 186 says is you're either an elected member or you're qualified to be elected. There's no reference there to whether you are on a list or not, as the case may be. But of course, we say presumptively, if you are on a list, you're qualified to be elected because you will have had to have gone through a process of verification when your name was...
But even so, the challenge of qualification is extant or dependent on a challenge. In other words, if you appoint somebody and there is no challenge, then the person is appointed. Somebody challenges it and says you're not qualified, then that is...
Yes.
Yeah, and again, Mr. Mendes, this may not be relevant to this case, but when you look at B of 53, it can't be saying that once you're blind, you cannot be elected or you're not qualified. That can't certainly be the intention of the Constitution of Guyana, which adheres so much to human rights and the rights in international conventions.
I think they're saying that the requirement that you're able to read the English language would not apply if you're blind. It says that you must be able to speak and, unless incapacitated by blindness or other cause, to read the English language. So that the requirement is that you're able to speak the English language, but if you're blind, you're not required also to read the English language.
So language is a requirement.
Able to speak, but not necessarily read if you are incapacitated.
Yeah, so a person with a disability that cannot speak. As I say, it may not be relevant, but there may be things that... Yes, there may be things, and the whole issue of language,
Yes.
I think that is something at some stage, Guyana may want to look at a little more closely.
Of course, we need.
Thank you.
But the point is that in this case, there was no allegation in the pleadings that the second and third appellants were not citizens of Guyana or didn't speak or read English, or they were disqualified by virtue of one of the criteria under Article 155. That was never a part of this case. There was no allegation to that effect. But the point that I was making earlier on is the fact that they were on the list of candidates meant that they had to go through the screening process that was required to be on a list, which is that you had to swear that you met the criteria, and there would have been avenues for challenge at that stage, so that they survived that and they remained on the list, and therefore they are presumptively qualified unless someone comes to court and say you are not qualified because you're not a citizen, or you can't speak English, or you are a citizen of another country, etc. So that was...
Of course, if one of the 33 extracted members becomes disqualified or dies,
yes,
then one of the 83 can then be extracted.
Yes.
And, well, there were consequences which the Constitution sets out. If they had been appointed parliamentary secretaries and they now become extracted, then they would now have the right to vote.
That's correct. And so the scheme here is that if you are not already an elected member of the assembly, in which case you would have already had the right to vote, then you automatically become, upon appointment, a member of the assembly, but you can't vote. And then if later on you become an elected member of the assembly, because you've been extracted...
How does this give the party... So the president is elected by the election,
yes,
and the president appoints the parliamentary secretaries.
Yes.
Right. Allowing, if it is that a person who is not on the list but qualified, 53, not disqualified, 155,
Yes.
can be appointed by the president
Yes.
as a parliamentary secretary, non-voting, but has voice.
Yes.
So that's your scenario.
Well, no, it's not.
No,
our
no, no.
scenario.
When I say
That's another scenario.
yeah, it's another scenario. When I say that's your scenario, what I mean is your construct allows for that.
Yes.
So my question is, from your point of view, how does the party or the president choosing somebody from the list versus somebody who's not on the list, but qualified, etc., give some sort of special advantage to the governing party? Because, okay, a person on the list presumptively is loyal to the party, but then the president could appoint somebody who is not on the list, but qualified, etc., who is also loyal to the party. In either case, they don't have a vote, but both have a voice. So what difference does this make? What's at stake in the choice between a parliamentary secretary on the list or off the list? What's at stake? Why is this an issue?
In this case, Malone?
Yes, in this
Your Honor, well, it's not an issue in this case.
No, you missed my
Because
point. I'm not on the question of not on the list.
I see, okay.
I'm asking a more pragmatic question. I understand the issue in this case is the challenge because you're on the list. I'm
Yes.
asking, the question I want to ask is, what difference does it make practically, given you have no vote but you have a voice and you can appoint a partisan person any which way?
Because in the effect of the respondent's submission is that you are an elected member of the assembly because you are on the list even though you're not extracted. And therefore, you do not automatically become a member under Article 186.3. So you're a parliamentary secretary, but you're not a member of the assembly, so you do not have a voice in the assembly. That is the effect of their submission.
Mr. Mendes,
Yes, Your Honor.
Article 186.3.
Yes.
What is the rationale? I've been struggling to find the rationale behind Section 186.3. Could you help us?
That is to say, the making of the parliamentary secretary a member,
Yes.
so that the parliamentary secretary can attend the assembly to assist the particular minister in whose ministry the parliamentary secretary is appointed, and possibly to provide information or to make contributions, but not vote. So that there is a certain level of participation.
Your speak as well.
Speak as well, the Honorable Attorney General says, so that they'll have those privileges as members of the assembly, but they can't vote.
Am I wrong in seeing some comparison between this and, say, for instance, junior ministers in cabinets, in systems where you have a Senate and an assembly and a
Well,
parliament? Or is it?
no, because with the junior ministers, I think that they would be a member of the Senate, or they could be a junior minister and a member of Parliament, so that they would have voice in either the Senate or the House, because they are already members of.
That's if they're elected to Parliament, but let's assume they're
Yes.
not elected to Parliament.
Well, I'm not aware of off the top of my head, in any event, of provisions which allow you to appoint someone as a junior minister, even though you're not a member of Parliament, either in the Senate
You
or
first
in
appointed
the
a
House.
senator, and then
If you're appointed a senator, then you're appointed, and then you. But what happens frequently is that sometimes the minister, if a minister is a member of the Senate, for example, and he or she is piloting a bill that is before the House, then the minister will have audience in the House to make a presentation, and vice versa, but not vote in the House or the Senate, as the case may be. So it is a question of difference between having your voting rights and your other privileges in a particular House. In this instance, Article 186 is providing for parliamentary secretaries who are not already elected members of the assembly to become members without the right to vote.
Thank you.
That's essentially what it is.
Mr. Mendes, is there anything, for example, when there was a constitutional reform and so on, and documents were produced, is there anything that you could point us to that would assist us in looking at the objectives of Article 186?
Not off the top of my head, my lady. I must confess that I didn't think it necessary to to do that because it appeared
Let me be a
very
little
plain.
bit more specific. I think as Mr. Justice Chang's judgment, he speaks about that role being reserved for technocrats.
Yes.
Is there anything in the Hansard, in the Constitution, in any travel preparatoire, anything that, or is there any convention that supports the view that you should not appoint members on the list because that space, so to speak, is reserved for technocratic persons?
I'm not saying that they don't exist, Your Honor, but I'm not aware of it because I did not do the research to determine that. Not thinking that or I should say, thinking that the provision was so clear.
Maybe you could ask Mr. Nanla.
I'm sure that he's taking note.
Will speak. The interpretation you have given, Mr. Mendez, of 186.1 does allow for that possibility.
Of course it does, yes.
But all you're saying is that there is no tradition or practice documented in the preparatory documents that lead inescapable to that position.
I'm not saying that there isn't. I'm just saying that
You're not aware.
I haven't looked for it.
Okay.
But it is, and the point too is that you may in fact have persons on the list who have not been extracted, but who are technocrats and who are being selected to be parliamentary secretaries because they have an expertise in a particular area.
Because in response to what the President asked, I thought you said that there was no limit. Is there a limit to the number of persons who may be on the list?
On the list, yes. No, there's no limit.
All right. So you could have hundreds of persons.
That's correct.
Some of whom have technical competence to offer.
That's correct.
Yeah.
And indeed, they may be put there for that purpose, so that they can fill these roles, these non-voting roles in the assembly and operate as technocrats. It may be that that is would be part of the thinking when the list of candidates is drawn up.
Mm-hmm.
And it would be quite wrong, I think, to assume that persons on the list have no technical skills.
that as well.
Wrong and unfortunate.
Although we all know the story about Dr. Eric Williams and who he could select in any seat, but
Guyana, yeah.
But you're saying, Mr. Mendez, that it's not restricted to persons on the list anyway.
no, it is
You
not.
have no problem with persons not on the list being appointed once they meet the qualification.
Once they're qualified to be elected as a member of the assembly. Those are the words that are used in 186.
And isn't that what the respondent argues? Isn't that what the respondent argues?
The respondent argues
In terms of who could be a parliamentary secretary?
no, I'm not. If I don't think that there is a disagreement with us on that score.
So the disagreement is that the sole disagreement is not from the list if not extracted. An unextracted list, but has to be list. An unextracted member cannot be appointed parliamentary secretary.
No, that is not, I don't understand that to be their case either. What they're saying is that an unextracted member of a list is already an elected member of the assembly. And therefore, Article 186.3 does not apply to them because Article 86.3 applies only if you are not already an elected member. But of course, the anomaly there is that they are saying that although you are already an elected member, you cannot be deemed to be a member But which begs the question, if you're already elected member, then what is the quarrel about? And that is what gets us into the interpretation of the phrase elected member of the assembly in the first place. But I say I don't understand them to be saying that that you're not qualified to be appointed as a parliamentary secretary. The case started off in that way, in that they were saying that the second and third appellants were not qualified to be elected at all, quite apart from not qualified to be a member of the assembly. But they dropped that first part of the case, because obviously, if they were correct in saying that being on the list meant that you were an elected member of the assembly, then you fit the first criteria of 186(1). So you were qualified to be elected because you're an elected member of the assembly. So I'm assuming it is on that basis that they did not pursue.
So in their construction, because of that, what? They have a right to vote?
Well, no, because they are on the list.
So, well, that's it. So that's...
Well, that's the point.
Yeah.
Well, that is why they interpret it. That is why the construction of the phrase elected member of the assembly, you can be described as such, even though you have not been extracted from the list. You're just on the list and you don't attend parliament, you don't vote, you don't do anything. This is why we say it just does not make any sense.
But in the view of some people, this is also quite critical. Are they paid?
Are they paid as elected members?
Yes.
I don't think so. No. As a matter of fact, I'm sure not. I don't even have to get instructions on that question.
That is quite critical. I would have thought. Yes.
No, they're not paid.
Certainly not paid as elected members of the assembly.
Yeah.
So
would they, just to take it a little further, would they enjoy all the other perks and privileges of elected members? I'm assuming elected members have a whole portfolio of privileges that they enjoy. And if these are parliamentary secretaries, do they enjoy, and do the other 80-something people on the list enjoy any perks of the office of elected member?
Nothing.
Nothing, yeah.
Nothing.
And when it comes to voting for bills in the House, which requires a certain percentage of elected members, they are nowhere to be found there either.
They're not there.
Yeah.
And that's the absurdity with respect of the position that was taken by the respondent. And
Mr. Mendes, can I take
to be
you
fair
to
to-
a slightly different point?
Yes,
Because, I mean, the first instance, the Court Chief Justice at this instance, and then in the Court of Appeal, they both felt themselves constrained to follow the decision of Chief Justice Chang,
Yes.
right? And are you aware of a decision, Trotman versus the Attorney General? Trotman.
Hoffman?
Trotman. T-R-O-T.
Yes,
Yeah,
that
yeah.
is the one that was also cited by
Right.
the.
So
Court of
in Trotman, that's a decision of the Court of Appeal.
Yes.
It's a little different. It's about appointment of ministers. But in your reading of Trotman, does Trotman say something different to what Chang said? In particular, did Justice of Appeal Cummins, as she then was, say something different? And if so, before the Court of Appeal, how was the Court of Appeal bound by stare decisis if you had two Court of Appeal decisions that were, on the face of it, saying different things? So my question is twofold, because one of the things that comes before us is that the first and second tier courts were bound.
Yes.
And I am asking about Trotman, but I'm also asking about whether the Court of Appeal on the Young and Bristol aeroplane theory was bound.
That of course is, as you will see from our notice of appeal, is one of our grounds of appeal.
Yeah.
But of course, because we were limited to 12 pages, we couldn't develop the argument, but that argument
But
is
I'm asking you about it.
Yes, it's developed in full in our written submissions
Yeah.
in the Court of Appeal, and it's on the record. If I can divide up the answer to the question to the two different decisions, first the Maureen decision, that is the Justice Chang's decision, and then the Trotman decision. As far as the Maureen decision is concerned, our case before the Court of Appeal was that at the Court of Appeal level, the only issue that was argued was a question of jurisdiction. That is to say, whether the particular complaint could have been brought by the procedure that was brought rather than by way of an election petition. And that was the only point that was decided, argued and decided. The court did uphold the decision of Chief Justice Chang, but the question as to what an elected member of the Assembly meant was not argued before the Court of Appeal. And our argument to the Court of Appeal was that if you look for the ratio of the Court of Appeal in the Maureen case, you can't say that they decided that elected member of the Assembly meant what Chief Justice Chang said it meant. It was not the ratio of the case in the Court of Appeal because it wasn't argued.
Mendes, sorry, weren't there written submissions on the other issues?
I don't recall if there were written submissions, but in any event, it was abandoned before the Court of Appeal, so it wasn't actually argued. So we cited a number of authorities which indicated that if the case
was it expressly abandoned?
Yes. So the court noted in the judgment that it had been abandoned, and therefore they made no pronouncement on the point. And so we argued that for that reason, there was no decision of the Court of Appeal by which this court was bound.
But the court did uphold the substance of what Chief Justice said.
They did not, because it was not argued before them.
Did they not affirm the decision of the Chief Justice in its entirety?
They did, as far as I recall, but as I said again, it was not a point that was argued, and we cited authority to them to indicate that where a point is accepted as correct without argument, then that is not to be treated as the ratio decidendi of the case for the purposes of stare decisis.
So if I interpret you correctly, you're saying that George's CJ was bound by the decision of Chang, but that the Court of Appeal was not.
No, we're saying that George's CJ was not bound by Chang's CJ either, although of course she would give his decision due respect. But
that was a first instance decision of Chang.
Yes, because we were saying that all you had was a first instance decision of Chief Justice Chang.
Yeah.
And therefore Chief Justice Georges would treat it with respect but was not bound by it. And likewise, because the Court of Appeal did not uphold expressly after full argument that aspect of his judgment, the Court of Appeal was not bound by its judgment either. So that was our argument.
Wouldn't it be, I accept the argument, if you don't mind my saying so, for the technical that you put forward. Would it not be more straightforward simply to adopt the approach of the Court of Appeal and to come to us to say, well, with respect, Chang CJ was wrong in his conclusion? Isn't that the more straightforward way of doing it than adopting these technical arguments about what was held by the Court of Appeal in the Maureen case?
Well, we did say that. We did submit that Chang CJ was wrong.
Yes.
And we made that submission to the Court of Appeal, but the court said that we are bound by our decision in the Maureen case.
And said that it was a matter for the Caribbean Court of Justice to resolve.
That's what they said.
So I'm saying, why not have us resolve it?
Well, this is what we're asking you to do now.
Yes, but you're using technical arguments about the scope of the decision by the Court of Appeal, rather than simply saying that regardless of what was said there, we think that this was a wrong decision.
No, I haven't made that argument here, Your Honor. I was answering, Your Honor. I was saying, he was asking me what was the position before the Court of Appeal.
Okay.
And I was indicating that before the Court of Appeal, we were saying to the Court of Appeal that you are not bound by your decision in Morian, because your decision in Morian was not a decision that fulfills the criteria for stare decisis. And we cited a number of authorities. There's a long authorities dealing with it. If it interests you, Your Honor, it is part of the record. Page 118 of the electronic record onwards, you'll see a cite a number of authorities which support exactly what I've just said. And it's respectfully, it's far from a technical point of view. It's a very substantive, because it is saying that if a court has not heard submissions and has not pronounced upon those submissions, then you can't treat the decision of the court as being binding on future courts. That's basically what it amounts to.
Yeah.
As far as the Trotman decision is concerned, Your Honor, the Court of Appeal decision itself, I don't read it as deciding the particular point that is before you today, although it appears that Chief Justice Singh at first instance in that case may have decided it, but we have not been able to get a copy of his judgment to put before you, although we have asked for it. So as far as, and when we were arguing the case before the Court of Appeal, the Trotman decision was not brought to our attention, so that we could not make any submissions in relation.
I wasn't sure, I'm sorry.
Sorry.
I wasn't sure of the position of all the judges in Trotman on the point. I think that Cummings, J. actually then was pretty clear on what her view was. Was there Ramson J. as well involved in that case? Yeah, who did not seem to have dealt with the point.
No, he didn't deal with the point.
But there was a third member of the court, and for the life of me, I've not been able to locate his judgment. So I wasn't quite sure whether he sided with Cummings J.A. on the point about whether the appointments were premature.
From the printout that we have, is not clear. It was Justice of Appeal Roy, but there's nothing recorded in the printout we have as to what his position was. Those are the judgments that we have. There's no notation as to what his position was, but
those are the ones we have as well, and we did not see Justice Roy's opinion.
But he does say, this is Justice Ramson, at the last line of his judgment on page 1155, that the jurisdiction issue apart, we find that the judgment of the learned Chief Justice was unexceptional, and subject to the ruling expressed herein, his judgment is affirmed. So that he, but again, we don't have the Chief Justice's decision, so we're not entirely clear as to exactly what he said. But Your Honor, you're right. This is why we haven't raised anything in relation to the stare decisis point, because we are asking you to, as the Court of Appeal has invited you to clarify this issue of law as to exactly what elected member of the Assembly means. So if I can take you to that definition first of all, and if I can just make the point that the differing views before you is that elected member of the National Assembly means those persons who have been extracted from the list and sit in the Assembly, have taken up seats in the Assembly, and the opposing construction is that it means all persons on a successful list of candidates, and success is measured by the fact that at least one seat has been allocated to your list. So those are the competing interpretations. The definition of elected member of the Assembly.
Just to be clear,
yes,
of course, you have a PR system in Guyana. So you can have multiple parties.
Yes.
So you have 10 parties. Party number 10 under PR system has enough votes to secure one seat allocation in the Assembly, but has a list of, like everybody else, 100 and, I forget what number you told me, 133 or something. On this second construction, all the members on the list of party number 10 that has secured a seat in the Assembly based on the PR system are elected members.
That's, as I understand.
So it's not just, it is theoretically, because under PR, of course, it is a multi-party system. It
Yes.
encourages that. So that's what that means.
Yes.
Yeah, okay.
So if you have 10 parties with 10 lists and each has 100 names on the list and each is allocated one seat, then you have 1,000 elected members of the assembly.
I mean, that's just absurd. Isn't there a provision that says that there are 65 members of the National Assembly?
Yes, Your Honor.
So where do we go from there?
Well, Your Honor, in my submissions, I said that the effect of the submission of the first respondent was that in this particular case, you had over 300 elected members of the Assembly. And my learned friend did not say in his reply that I was wrong, that was not what he was submitting. But it follows logically if you say that all members on a list, and this is what Chief Justice Chang said as well, that all members are on a list are elected members even before extraction. So all of them are elected members.
It's a difficulty. It's a difficulty, and it's difficult to reconcile with logic, difficult to reconcile with many provisions
Of the Constitution.
So, but there's just one small point I wanted to bring your attention to, and that is in Section 60 of the Constitution.
Yes.
And paragraph 1 thereof. And it references the fact that election of National Assembly members
Yes.
shall be by secret ballot.
Yes.
And I would like for you to explain to me how that is consistent with the election of the members of the National Assembly being by way of extraction by the list representative.
Well, the election there is by the voters. The ballot is by the voters. So the voters' ballot is secret.
Yes.
And you're voting for the persons on the list.
But you are saying that those persons are not elected members of the Assembly.
Well, no, exactly. Well,
The minute
exactly.
pause.
Not until they are
Mr.
extracted.
Menendez, are you voting under the PR system in Guyana? Are you voting for persons or party that puts up a list?
You're voting for the list, but specifically as far as the president is concerned, you're voting for the
Yes, no.
person on the list.
President apart,
No, you vote for lists.
for lists.
Yes.
But you vote for lists as a generic list of a party.
Yes.
Yeah, that's what you vote for.
You can't-
You don't vote for Peter Jamada
No, you
on a
don't.
list.
No, you don't. Except in the case of the president.
And that, yes, I know that, yes. So that is the secret ballot is the ballot that is cast secretly to choose your preferred list. Yes?
It is my ballot as an elector, which is secret.
To choose a list. Forget the president for now.
Yes.
Then, once that attains certain numbers, the Constitution and the Representative People Act provides how you you divide that up, how
Yes.
you divide that.
That's correct.
Then it falls for the listing, what's the expression? I forgot.
List
now.
representative.
The list representative to say who on that list will sit.
That's correct.
Correct?
Yeah.
Yeah. So the secrecy of the ballot, the integrity of that in the democratic system goes to the choice of
Of the list.
of the
Yes.
list.
Yes.
I'm looking at the time, Mr. Mendez. Now, Mr. Attorney General is going to address us? No.
Unless the court wishes to hear me.
I see. Okay. Okay, fine.
How much more time do
So
I
you
have?
have about 10 minutes.
Well, thank you. Yours. Well,
Mr. Mendes, could I
Yes,
take 1 minute of your 10 minutes?
yes, please, yeah.
Yes. In trying to understand the judgment of Chief Justice Chan, was wondering whether he was not drawing a distinction between an elected member and an elected member of the Assembly. Because if unextracted members are members, it doesn't face the calamity which you have exposed in terms of the numbers of members of the National Assembly.
If unextracted,
Yes,
yes.
yes. What I'm saying to you is, if Mr. Justice Chang is referring to members on the list, or names on the list
Yes,
as members,
yes,
not of the National Assembly, because when you look at the Constitution talks about members of the National Assembly.
yes.
Doesn't that solve the problem that the numbers problems that you so eloquently
Well,
highlighted?
if all he decided was that persons on the list are members of the list, then that would not affect this case at all, because as a matter of fact, there's no such thing in the Constitution as a member on a list. That category of person is not dealt with anywhere in the Constitution. What we are concerned with is the phrase elected member of the Assembly.
One 186.1,
Yes,
or are qualified to be elected as such members.
yes, members of the Assembly.
You've added on of the Assembly.
Well, such members, the only members previously referred to are members of the Assembly, so it could only be a reference to members of the Assembly.
That's an argument.
Sorry, Andrew?
That's an argument, but I'm wondering
Well, it's,
whether Chief Justice Chang sees it that way.
Well, I understood Chief Justice Chang to be deciding that, and there are passages that have been quoted in the submissions below where we developed the argument and criticized his judgment in more detail, where he said that as long as you're on the list, and as long as seats are allocated to your list, or I should say, as soon as seats are allocated to your list, then everybody on the list become elected members of the Assembly. He didn't say members of the list. He said of the Assembly. He was referring to that, to the phrase elected members of the Assembly, applying it in relation to the appointment of ministers.
I'm wondering, Mr. Mendez, if I don't remember him saying elected members.
Well, if he limited it to elected members, then Chief Justice George was not bound by his decision, and the Court of Appeal didn't uphold any decision that elected members of the Assembly include everybody on the list. So that then, if that is how his judgment, if I have misconstrued his judgment, then I'm happy that.
No, I'm not suggesting that you have. I'm not suggesting you haven't.
Well, what I'm saying, if that is the correct interpretation of his judgment.
But what you've exposed is a calamitous numbers situation. If one views every member as a member of the National Assembly.
Yes,
I can see that. But what I'm wondering is whether Chief Justice Chang was suggesting such a ridiculous, such an absurd result. I think that perhaps he was limiting himself.
Well, if he was, he didn't say exactly how he was doing so. So therefore, we were left, and this is how Chief Justice George interpreted his judgment as well, as deciding this particular point. And then she felt herself bound by the Court of Appeal's upholding of his decision as well. So they all proceeded on the basis that he had decided that all names on the list were elected members of the Assembly. And we, of course, are asking you to overturn that and to say that.
But Mr. Mendez, even in 186.3, in 186.3, the language is suggestive of a distinction between elected member of the Assembly and a member of the Assembly. In the latter case, it's the Parliamentary Secretary.
Correct.
So 186.3 appears on the face of it to recognize that an elected member of the Assembly is a category different from a person like a Parliamentary Secretary who becomes a member of the Assembly.
Correct.
So that for myself, I'll wait to see how this is developed, but
Well, if I may just, because I have limited time, if I may just, my submissions are there, and of course I rely on them in full. But if I could take you to the definition of elected member and election, this is on page 796. And you see, elected member of the Assembly means any person elected as a member of the National Assembly pursuant to the provisions of paragraph 2 of 60 and Article 162. And then election is defined as meaning an election of members to serve in the National Assembly or other elected body established by and under the Constitution. The point being that the consequence of an election to be held clearly under the Constitution is that you serve in the Assembly. So what is the point of saying that you are on a list, you are an elected member of the Assembly, but you are not serving, you're not being paid, you don't have to come, etc., etc.
You're just reading from the Constitution?
Sorry?
You're just reading from the
I
Constitution?
was just reading from the Constitution.
I know you have limited time. Did you want to take us to the Representation of People's Act and just indicate how that helps or hurts your argument?
Yes, and in the Representation of the People Act, you'll see that certainly the legislature considered or was using language which was consistent with the way in which the appellants are proposing that the Constitution be interpreted. And you'll see this at page 1042. It says when seats
What
have...
section?
Section 98, at page 1042. It says, where seats have, in pursuance of Section 97, been allocated to any list of candidates, A, the representation of the lists, and then it said A, and then it deals with different scenarios where the list representative is not making the extraction, and then it goes on, shall extract from the said list as many names belonging to the candidate selected by him for the purpose, including his own name, if he has not been declared elected as president under Article 177 of the Constitution, as can be so extracted without their number exceeding the number of seats allocated to that list. And the chief election officer shall declare such names in the order of their extraction as aforesaid to be the names of the candidate on such list who have been elected. So the language that is being used there is that the persons who are now extracted to fill the number of seats allocated to the list are the persons who are declared to be elected. And then if I can ask you to look at Section 99A.
Yes.
Yes.
Is the practice, the parliamentary or the assembly practice, do people who are elected members swear an oath?
Yes.
So is there an oath taken, and does that oath signify their status?
Well, it's the oath is at Article 167, and you'll see that at page 682. And it says, no member of the National Assembly shall take part in the proceedings of the Assembly, other than proceedings necessary for the purpose, until he or she has made and subscribed before the Assembly the oath of office.
So therefore, this process of who becomes a member starts in a place and culminates subject to different things in the taking of the oath.
Yes.
Until you take, you could have gone through all of this.
Yes.
Until you take the oath of office, you're still not completed the process. And therefore, by exclusion, if you've never taken an oath of office, which is provided for in the Constitution to declare to the country that I swear, affirm, whatever it is, etc., then you simply, I honestly do not see it.
Well, let me put it this way. There's no unextracted member of a list, as far as I know, who has gone to the Speaker and said, I'm here to take my oath because I'm an elected member of the Assembly in accordance with the judgment of Chief Justice Chang. No one has done that.
Along those lines, Mr. Mendez, what is the tradition in Guyana, if there is one? The person who has not been extracted, what is that person referred to? Someone on the list? The person who has not been extracted?
There's no formal.
There's no special, it's just, yeah.
I don't think that there's any nickname or anything of that sort.
Yeah, no, I just wondered, not the nickname, but I wondered whether there was,
There's no rule set out in the Constitution or the Representation of the People's Act for those persons. There is nothing to suggest that they are pigeonholed in any particular role or that they're in any way different from persons who are not on any list or qualified.
Except that they are eligible for extraction in the event
that
there's
they're
a
eligible for
vacancy.
extraction.
and that is in section 99A, which I'll ask you to look at as well, because it's long, so I wouldn't use up time. But in that section, there's clear distinction made between persons who are elected members of the Assembly, and that section does not treat the unextracted or the yet to be extracted members as elected members of the Assembly. The language that is used does not treat them as elected members of the Assembly. They will become elected members of the Assembly if they are now extracted to fill the vacancy, and that is the clear import of section 99A. I didn't want to use the time to read it out because I think Justice Anderson was about to ask me a question.
I'm with you. Yeah.
You're out of time.
Yes, well, those are my respectful submissions.
Yes, thank you.
Thank you very much.
Mr. Ford, I trust that you have been hearing us and following us without any technical interruptions or difficulties.
I've been, Madam President. Sorry, Mr. President, sorry.
Yes, please proceed.
Your Honors, there is no doubt that this case raises important points for the clarification of our law, and we are very grateful for the court's role in this matter as contemplated by the Constitution. But Your Honor, much of the questions that Your Honors have asked, I believe that I need to start by just recapping it in the context of the system, the electoral system that we have in Guyana, which is one of proportional representation. Your Honor, in the context of proportional representation, as Your Honors pointed out, there's no specific voting for any particular candidate that would appear on the list. And Justice Chan's decision, which really, in my opinion, Your Honor, reflects a long line of not only practice, but interpretation of the law, going back as much far as the decision of Justice Singh in Trotman's case, and which was upheld on appeal in Trotman's case. Despite the fact,
Mr. Ford, do you have that judgment of Justice Singh that you can share with us?
No, Your Honor, but I will certainly make contact with him personally. I inquired from the court, and they seem not to have it available, Your Honor. But I'm going from the Court of Appeals decision, Your Honor, which seems, based on the very appeal from the Court of Appeal, that it is regarded and considered as an affirmation by majority of the decision of Justice Singh. So you wanna, when we look at that case, what a case would have decided, Your Honor, Justice Jamadar asked a very important question. What is this all about? Why is this such an important issue? And I believe when we examine the case of Trotman, we could see one of the important underlying issues which could arise if the interpretation advanced by my lawyer friends on the other side would be accepted. In Trotman's case, Your Honor, the issue is whether the president can appoint to members of the executive without first appointing persons to the National Assembly, without the National Assembly first being constituted. If we accept the argument advanced by my lawyer friends on the other side, it would mean that the decision of the Court of Appeal and Justice Singh in the High Court would be incorrect, and we would lead to a conclusion where you must first have a constituted extraction process, and that you must first become a member of the National Assembly before the president could proceed to appoint the executive. So that is one of the implications, Your Honor, which don't appear.
Mr. Ford, you need to go back over that a little bit more slowly for me.
Okay.
I'm not sure I understand.
Okay, Your Honor, in the Trotman's case, the issue is whether President Barajagio could have appointed ministers to his government without first the National Assembly being constituted and without first those persons being extracted and taking the very oath that Mr. Mendez referred to in Article 167, I think it was. That was the issue. And Justice Carl Singh, in the High Court and in the Court of Appeal by majority based on the decision that we are looking at, the Court of Appeal's decision, concluded that there was no obligation, no constitutional bar that required that those persons who would have been appointed to the executive be members of the National Assembly and members of Parliament first. So they upheld a decision, Your Honor, which has reflected not only the custom and practice, but what have been the law, of the common understanding of the law. Let me put it that way. That you must.
Where is it? That it seems to me that is a very different issue from the matter before us. As I understand you, and you tell me if I'm right, in Trotman, it was decided that the president can appoint ministers even though they were not members who had been extracted. Is that correct?
Yeah, there was no extraction would have taken place at the
done
time.
as yet. And it was
For any person at all.
and it was said that that was permissible.
Yes, Your Honor.
But that is not the situation here, is it?
Your Honor, it is not the situation here in terms of the actual facts, but in terms of how the court came to the conclusion. The court have to regard to Article 232 of the Constitution. And Article 232 of the Constitution, as declared by Justice Singh and in the Court of Appeal in the Trotman's case, they concluded they concluded, Your Honor, that in Article 232, there was no obligation that an elected member of the National Assembly means any person elected as a member of the National Assembly pursuant to Article 60 and 162. The Court of Appeal and Justice Singh concluded that those persons who, even though they were not yet extracted to become members of the National Assembly, but Your Honor,
Unmuted.
We're not hearing you right now. I don't know if you're hearing me. We're still not
I think
hearing you.
he seems muted.
Are you hearing us? Put your hand up if you are hearing us. Okay, you're hearing us, but we're not hearing you at all. We're still not hearing you.
He said 232.
Defines elected member.
An election.
hello?
Yes, we're hearing that.
I'm using another device.
Okay, we're hearing you now. Yes.
Sorry about that, Your Honor. I was saying, Your Honor, that the interpretation of Justice Singh, it came to the conclusion that even though you were not extracted by virtue of the Article 232, the definition of elected member of the National Assembly, because the president had to appoint someone who was a member of the National Assembly. The ministers ultimately had to be a member of the National Assembly. And even though they were not yet extracted, he concluded that there was no requirement for extraction to become a member of the National Assembly under Article 232. Justice Singh also went on specifically to point out that the process of extraction in Section 99 of the Representation of the People's Act were not specifically covered and captured under this provision. Now, Your Honor, I understand completely that it is, on the face of it, a most bizarre and ridiculous proposition to say that at the end of an election, we have a situation where we have 300 or 400 or maybe more, depending on the number of parties, as there is no limit to each list, elected members of the National Assembly. But I believe, Your Honor, that that is a specific interpretation coined by the Constitution to create a number of consequences. First, Your Honor, it is to create two distinct categories, which are never meant to merge, between persons who are qualified to be elected and those who would have been on the list as members of, as a candidate. Your Honor, Justice Saunders, you asked a very critical question, and I was smiling at the very commencement. You asked the question, what is the tradition, what is the convention, and what is the rationale for these provisions in the Constitution? It is this, Your Honor. Your Honor, we have had a system which would have largely restricted the president to only identifying persons who appeared on the list. During the constitutional reform processes, it was then decided that the president and the nation at large can benefit from the skills of persons who do not form part of the usual russ and tussle of active politics. So it became part of the vernacular of the nation to refer to such persons as technocrat persons. And as Your Honor pointed out, it would be ridiculous to say that our political parties cannot identify persons that have technocratic skills on the list. So it is not meant to be derisive in any way, but it was descriptive in relation to persons who are non-elected members of the National Assembly. Your Honor, when you look at Article 232 of the Constitution, you would find, Your Honor, that it is very precise as to the provisions it is referring to. It's referring to Article 62 and 162. And Your Honors will see 161 and 2. And you will see that in Article 163, there is then the provision in the Constitution that empowers Parliament with the authority to proceed to make arrangements and provisions for the extraction of members of the National Assembly. On the definition, we respectfully submit, Your Honor, that it is the Constitution's intention, having regard to the fact that I earlier advocated before Your Honors with respect, the creation of two separate categories. It is the Constitution's position that extraction does not form part of the electoral system. It is not part of the election system. The system of the elections is set out in Article 60 and 160, a list, a geographical area, and then we have the fact that the seats are allocated proportionately. That is what the Constitution is speaking about in relation to persons who would have.
The extraction does not form part of the electoral process, yes? Is that what you said?
No, Your Honor, it doesn't form, if I said so, I misspoke.
No.
It doesn't form part of the electoral system, that is particularly laid out. Sorry, Your Honor, that is system that is laid out in Article 60, Article 62 and 160.
All right, so can I just ask you to pause for a minute? What is the function of the electoral system in Guyana? What is its purpose and function?
The purpose and function is to ensure that the nation, the electorate, they're able to elect candidates
to represent them.
In the National Assembly,
So the electoral system serves the purpose through proportional representation and democratically to afford citizens an opportunity to choose their representatives who will represent them by sitting in the National Assembly. That is the end point of the process. i.e., is that not right? That is to say that the process culminates in representatives of the people serving them by becoming members of the National Assembly of Guyana. Would you not say that is the whole purpose of the electoral system?
Yes, Your Honor, I would say that that is the entire purpose of the system. As in the end. But Your Honor,
but it's a process leading to an end, right?
Yes, Your Honor, it's a process leading to an end, but in this situation, and I would like to point out why it is not the same as in Trinidad or Barbados, where it is the same process leading to an end. In Barbados, it's the first past the post system. When you're elected, you're directly elected, you go directly to the House, or the House in Barbados or Trinidad. In this situation, Your Honor, this raises certain deep philosophical and jurisprudential questions. In the context of a parliamentary system that we have, of a proportional representation system, can we say that the role of the list representative, who is tasked, and I have referred to the decisions, the decision of the court in Kumar, a decision by Chief Justice Bollers that examined the role of a list representative at that time, and in the context of this time, Justice Saunders asked a very critical question. Are the names extracted 1, 2, 3, 4, 5, or is the list representative imbued with the discretion to roam throughout the list and to pick who he wishes? And it is the latter situation. I pointed out in the submissions in the Court of Appeal, and I tried to abbreviate it in the CCJA submission, to point out the role of the list representative and how it has evolved over time. When the role of the list representative under the previous system, once your list would have received 10 seats, you pick the first 10 persons. It's a purely simple process. In the latter system, which evolved over time, the list representative would now
Mr. Ford, you say evolved over time. Hold on. Doesn't the existing system have the imprimatur of the Representation of the People's Act? Is that not the law? You had a simple list system. You put up a list, and depending on the proportions, you choose the first 2, 5, 7, depending on what your allocation is. That's the simple list system. You had that, correct? At some point.
Yes, sir.
Right. Then the will of the people, you have the existing system where you have a list, but your Representation of the People Act allows some person called a list representative to make choices from that list. Is that right?
Yes, you are.
Well, that's the model you have chosen. Are you criticizing that as in some way? Are you saying that is undemocratic, or I don't understand why. What is the point on the change in the list?
Your Honor, I'm not saying it is undemocratic. I'm saying the interpretation which is given by the appellants to the entire process to recognize when the Constitution does not specifically in Article 232 include extraction would be including in an electoral system where the Constitution defines what is the system, would be including the list representative as part of the electoral process in terms of identifying ultimately who are the candidates. That is who to go into the National Assembly. I believe, Your Honor, that is because of that system, because of the very fact that we have this type of system, that the Constitution shuts down the system as set out in Article 60 and 162, and then does not allow extraction to be part of the electoral system. And at that stage, Your Honor, the list representative makes and exercises his choice, because the decision of Justice Bollers pointed out that it is the list representative's choice. And if we're going to have an electoral system that is truly democratic, we must say that at some point, Your Honor, that the electorate is capable of choosing every single person on the list. Every single person on the list must have been considered to be elected, capable of then being extracted. So when a list representative acts, he is not electing by extraction a person. He's identifying any one of a possible list of 113, 114, as a person who would have been elected. No.
Pause there. I understand what you're saying. So, but when that choice is made by the list representative, what is his this is the number of this case, I think. What is his status designated to that choice? Because somebody has to choose in your system who is going to sit and serve and vote in the assembly. Correct?
Yes, sir.
So what is the designation given when that choice is made to that person who sits, serves, and votes in the assembly? What's the designation given to that?
Yes, sir. Your Honor, and we're going to the nub of the matter from how I see it. Your Honor, that person becomes a member of the National Assembly. The Constitution.
No, of the National Assembly.
Right?
Yes, Your Honor. Yes, Your Honor. But the Constitution itself provides that after the election is completed, they provide for the extraction process. Then they provide for the 65 persons to become the member of the National Assembly, and they take an oath.
Just pause. At that point, if I were to ask you, who are the members of the National Assembly of Guyana? How would you answer that question? Would you answer that question by saying the 65 members who have gone through the entire process and taken the oath?
Say that those are the elected members of the National Assembly.
Yes.
You see, Your Honor, what?
Mr. Ford, try and, if you would, go along with me.
Okay.
Would you not designate those persons at the end of the process, having taken the oath, as the members of the National Assembly of Guyana?
Yes, Your Honor.
Right. And do they not as become office holders with that designation and enjoy a portfolio of terms and conditions, rights and responsibilities under the law? They don't float in a vacuum. Yeah. And they are practical things. There's a code of ethics. They could come under parliamentary scrutiny and reprimand, discipline and reprimand. They have pension rights. They have
Immunities.
annuity rights. So when you designate them that as an office holder, things, concrete and practical things attach to that designation. Agreed?
Yes, sir.
Now, in contradistinction, the other people who were on the list before the extraction process, do they A, enjoy the designation, and B, the terms and conditions, rights and responsibilities that are attendant on that designation? Do they?
No.
Well, then I am struggling to understand how you can draw a line and talk about the extraction does not form part of the electoral system, when the electoral system is intended to designate and place named officials with rights and responsibilities in the assembly to do the business of the Guyanese people.
Your Honor, I was referring specifically to the definition of elected member of the National Assembly as set out in Article 232 of the Constitution. What we have here, Your Honor, is that we, my learned friends on the other side, have not pointed out, and I think the Court of Appeal in its decision pointed out the fact that in this Constitution, Article 232 starts off that in this Constitution, except as otherwise provided or required by the context. Elected member means any person elected as a member of the National Assembly pursuant to the provisions of paragraph 2 of Article 60 and Article 162. The Court of Appeal pointed out, Your Honor, that there will be instances in the Constitution where you may come to a conclusion that, in fact, if my argument is adopted, you're saying that it is 260 members would have to vote apparently on a no confidence motion, for one example. But Your Honor, when we recognize and read the Constitution as a whole, we can't come to that conclusion because the Constitution provides that 65 members are the persons who ultimately become the members of the National Assembly. Your Honor, we have in our system here, Your Honor, and I would ask the court to consider the implications of adopting the argument of the appellant in this case, because I am urging the court because it will have severe implications in the
Those
context.
implications are.
Your Honor, I pointed out the situation in relation to the Trotman's decision, which is my understanding that the effect of it would be that a elected president will, on the argument advanced by my learned friends, will not be able to appoint an executive until the entire parliament would have been constituted. The members would have to be extracted, they would have to be sworn in, and that will represent, obviously if the court so rules, it will be the law, but it will represent a radical change. It would mean, Your Honor, that successive governments who would have proceeded on this basis of an understanding of the law would have started off on the wrong foot, to put it mildly.
Let's forget Trotman for the time being. Let's speak about this case. What are the severe implications if the list representative is or is not able to select unextracted persons as parliamentary secretaries?
What is the implications, Your Honor?
I got to us that there are serious implications involved, and I want to know, in relation to this case, what are those implications?
Your Honor, it is my respectful view, as I indicated earlier on, that the Constitution created two distinct categories. That has been the interpretation advanced and adopted repeatedly in a number of cases. In fact, Your Honor,
Category of what?
Two different categories of persons, Your Honor, who could possibly become members of the National Assembly. Those who would have appeared.
Go ahead.
Those who would have appeared as candidates on a list, and those who would have been qualified for election, though they did not appear on the list.
But
the Constitution.
Slowly, let's go through this slowly, because this is important. Those who appeared on a list but were not extracted, they're also qualified, aren't they?
Yes, Your Honor.
Similarly to those who are on no list.
Yes, Your Honor, but they would have been qualified, and in our understanding, Your Honor, and this is the predominant understanding, if I may say so, Your Honor, because Your Honor will see that in the Morian case, the issue was raised. Mr. Nandalal, who's now the Attorney General, argued the reverse. And if we were supposed to go a bit further back in time, I know it's not the same facts. I'm not saying so, Your Honor. In Trotman's case, you would see generally the same train of thought. Let me put it that sort of way, Your Honor. So we argue, Your Honor, that there are two separate categories, and the Constitution created.
Started those who appear on a list but are not extracted. They are qualified, and you were going to say something else.
Oh, sorry, Your Honor. I was saying that there are two separate categories, and I will understand. All those who appeared on the list as candidates would have had to be qualified to go on the list to satisfy that requirement. And then there's a situation where our general understanding is that we have another category that the Constitution provided, capture persons who did not actively participate or go on the list as candidates. So there would have been two separate categories. That is our case, and that is our position, and that has generally
on the list being selected as parliamentary secretaries as opposed to persons who are not on the list. Why you don't want, I could put it in very blunt terms, why is it your clients are objecting, or what is the problem they have with persons, unextracted persons on the list being appointed as parliamentary secretaries? Why, in your view, the Constitution should be interpreted in a way so as to prohibit that?
Because the Constitution created two distinct categories. And when we look at Article 232, it defines and limits everything except the process of extraction. It could easily have said, Your Honor, Article 163, it could easily have added that provision, but it is specific in terms of dealing with the persons who would have appeared on the list. Article 160, 1 and 2, and Article 62. So we say...
Please assist me. These are categories of what? Two distinct categories of what, may I ask?
Of pathways to the membership of the National Assembly. Two distinct categories. And once you would have appeared on the list, based on the interpretation that we advance, you would have been an elected member of the National Assembly. Upon extraction...
You maintain that once you are on a list, even if you are not extracted, that you are a member of the National Assembly? Is that your submission?
Yeah.
No, Your Honor. It is what I'm articulating, Your Honor. What I'm articulating is that there is a definition specifically provided for elected members of the National Assembly in Article 232, and there's the broad interpretation which that captures. And as the Court of Appeal indicated in its decision, there is a narrow construction based on the very Constitution itself, which proceeds to say that persons who would have been extracted, that is only 65, you have to swear an oath, and you go on to be members of the National Assembly. In many instances, Your Honor, in many instances, for example, when you look at Article 186(1), Your Honor, it says parliamentary secretaries may be appointed from among persons who are elected members of the National Assembly or elected or qualified to be members elected as such members. And then when you look at 105, Article 105, just as an example, that attracted the court's attention in the no confidence case, Your Honor, and where is it? Your Honor. So when you look at Articles 1066, it says the cabinet, including the president, shall resign if the government is defeated by a vote of a majority of all elected members of the National Assembly on a vote of confidence. So the reason why I refer to this, Your Honor, is to point out, Your Honor, that in our view is clearly the same definition that has set out in Article 232 that excludes the extraction process. It's not the same definition that to be used in 106, the same interpretation, because it says in the context, Article 232 provides that you must apply the definition in the context. Certainly, Your Honor, the persons who would have been extracted would be the persons who would be actually sitting in the National Assembly and participating in the vote. There are other parts of the Constitution, Your Honor, even if like in Article 186 itself, it refers simply to.
Let's look at 186.1 and let's try and construe it. It says parliamentary secretaries may be appointed from among persons who are elected members of the National Assembly. Do you understand that to mean from among persons who have been extracted? First part. Parliamentary secretaries may be appointed from among persons who are elected members of the National Assembly. Do you understand that to mean from among persons, from among the 65 people?
Yes, sir.
Okay, and then it goes on. Or, it's an alternative, persons who are qualified to be elected as such members. Do you understand that to mean anybody in Guyana who does not suffer any of the disqualifications set out in Section 53?
Sure.
Sorry, Mr. Ford, did you agree?
Yes, sir.
Well then, if you agree on both of those propositions, what is the difficulty with a parliamentary secretary being appointed from among persons who are on a list but who have not been extracted?
But who qualify under the alternative? If Mr. Ford, if they can fall in the alternative category, if there are two sets, people who are actually among the 65 in the assembly, you say, and then anyone in Guyana who under Article 53, barring 155, can be elected, correct? In that latter bucket or category, would a person on the list who is not in the 65 fall into that category, into that bucket? How? Because would there not be a person qualified to be elected as you agreed to the president? You said that 186 allows two sets of people to become parliamentary secretaries. People, the 65 who have taken the oath. Yes, you agree to that?
Yes, sir.
Then in the alternative, the president asked you, would you agree that the second category, qualified to be elected, was everybody in Guyana who was properly qualified? You agreed to that?
Yes, sir.
Okay. So then people on the list would fall into the category of people in Guyana qualified to be elected, presumptively, because they got on the list.
You see, what you're doing and what, with respect to the judgment of Mr. Justice Chang does, is to disqualify from 186 persons who are on a list but have not been extracted. And I'm trying to find the source of that disqualification. Which article of the Constitution disqualifies them from becoming parliamentary secretaries? They're disqualified from voting in the National Assembly. And the Constitution specifically says so. But which article disqualifies them from eligibility to becoming parliamentary secretary? That's the hurdle that you have to overcome. That's what you need to convince us of, that there is some article here or some combination of articles that disqualify unextracted members on a list from eligibility to become a parliamentary secretary.
When on the face of it, they qualify under the alternative.
Your Honor, Your Honor, we say that that provision is Articles 232, Your Honor. I know that the court is, Your Honors have indicated that they are not in agreement with that proposition, but we say that that is so, Your Honor. When we look at Articles 103.3 of the Constitution, Your Honor, it provides that not more than 4 ministers and 2 parliamentary secretaries shall be appointed by the President from among persons who are qualified to be elected as members of the National Assembly. So it is the combination, that was our position, Your Honor, in the course below, that it is a combination of Articles 103.3 together with Article 232 that would have resulted in the 2 defined categories.
Okay.
Do you want to speak with us, Mr. Ford, about the Representation of Peoples Act and how, if at all, it affects your position?
Your Honor, the Representation of the People's Act, by the language that is used in the Act, Your Honor, Justice Chang, I believe following the same sort of thought from Justice Singh in the Trotman's case and in the majority of the Court of Appeal in Trotman case, concluded that you are elected because of the system of proportional representation. You are elected prior to even being extracted from the list by virtue of the language which would have appeared in section 98 of the Representation of the People's Act. That has been the submission in relation to the section of the Representation of the People's Act.
Is your reading of 99A?
Yes, Your Honor. And Articles 163 says that it confers power on the National Assembly to make provision for the extraction of persons from the list and the declaration of names who have been extracted. Sorry, who have been elected. I made a mistake. For the extraction from the list and the declaration of the names of candidates who have been elected. It has been construed, Your Honor, by the court, 3 times by the Court of Appeal, by 3 different Chief Justices, that you are elected even before the point of extraction.
Okay. Thank you, Mr. Ford.
And Your Honor, the court, in its composition this morning, asked one question as to whether we are really attributing such a ridiculous proposition to Justice Chang, and by implication, all the other Chief Justices and the Court of Appeal, that we are saying that, in fact, in Guyana, there are 300 members of the National Assembly. I don't believe that that is a fair conclusion to come to for the purposes of identifying the persons who are actually members of the National Assembly. Those persons will be restricted to 65 persons, and it is to those persons to whom the obligations and the duties and immunities will attach. But I believe, underlying the constitutional matrix here, Your Honor, was a situation where the Constitution, as to me, as how it has been set out, did not want to contemplate a situation where, having regard to the powers that could be exercised by the list representative pursuant to legislation passed only by Parliament and not put into the Constitution and have oversight by the Constitution as set out, did not want to put a situation in place where, ultimately speaking, as a matter of jurisprudence, that we have a system where people are ultimately elected by a decision of only one person. In the case of Kumar, Your Honor, that I pointed out, the court Justice Baldwin pointed out that in that case, that he pointed out, Your Honor, that even if, among his statements on page 190, even if I were wrong in this brief, and it could be rightly assumed that the list of candidates meant list of candidates of a political party, and that the intent of the legislation was that the list represented should select those candidates desired by the political party of which he is a member. Nevertheless, the legislature has given the representative an independent discretion when language used speaks of selection made by him. For it's a kind of construction that the legislature, in conferring powers on an authority, presumes that the authority will act honestly and in good faith. And if the non-part of his judgment, it says, counsel for the plaintiff submitted that the word selected by him in the regulations should be read as selected by him on the instruction and direction of the political party which he represents. And he said that the clear intention of the legislature, as expressed in the language, was that he should select those names desired by the party. And the court concluded, Your Honor, that that is not so. That was at the time, I believe, when we would have had the numerical system. And then we have now evolved by legislation to where the list representative could exercise his power. The Justice Borders went on to say that the list representative exercises an unfamiliar discretion. I believe that is the word and how he described it. So I understand, Your Honor. I understand. I don't want you to believe that I am coming here to offer you any disrespect by my submissions. But these are very important issues which are rooted in the peculiar construct of our Constitution having regard to a proportional representation system. That is why Justice Chan concluded, Your Honor, that every person on the list must be considered to be an elected member of the National Assembly. He's not saying that those persons will all go into the National Assembly as a right to turn up there, take the oath, and to vote and pass bills, because the Constitution itself proceeds to say that it is only made up of 65, pursuant to Articles 163, which is not captured in the definition of Article 232. Parliament went on to provide for how that process of extraction is to take place. So we recognize that, Your Honor. But are we going to say that as part of a national democratic ethos, having regard to the role that the list representative plays, that we're going to say that he exercises an unfamiliar discretion to elect how many persons have been assigned to a list? It is because of that underlying problem, I believe our courts came to the conclusion repeatedly and concluded that every person on the list, for the purposes of Article 232, subject to which it says in the context otherwise provided, should be considered an elected person. So it is not only this representative that proceeds to make that election. It is done by the will of the people. And he simply proceeds to identify. And based on what Justice Butler said, he didn't have to listen to the list. He didn't have to listen to the party. So how are we?
Mr. Ford, that actually does not help with the conundrum of 86.1. 86.1, you see, you said that the justification for disqualification of appointment lies in the conjoint construction of 86.1 and 3, 232 and 103.3, right? You remember you told us that?
Yes, sir.
Okay, that's it. But 103.3, I don't follow, because 103.3 does not do anything else than limit the number of people who the president can appoint. Isn't that right?
Yes, Your Honor. It does that. It does nothing.
Sorry.
It does nothing more. Sorry.
Right. Exactly. But what it does is, it does repeat the categories in 186.1, doesn't it?
Yes, Your Honor. It does repeat the categories. And when we look at Article 232, which is the governing provision, which provides the meaning.
That's the definition, right?
Yes, Your Honor.
That's the definition section, yeah.
Yes, Your Honor.
So what I'm still struggling to understand clearly is why you say 1033 helps us understand a justification for disqualification of, let's call them, list members. I'm not following that, to be quite honest. And before we close, if you can help me with that, because 1033 says not more than 4 ministers and 2 parliamentary secretaries shall be appointed by the president. And then look at the words. From among persons who are qualified to be elected as members of the National Assembly. And you said that included everyone in Guyana who properly qualified to be a member. So that all that 1033 does is says, you know something, you don't have untrammeled power to appoint whoever you want. You could only appoint 4 ministers and 2 parliamentary secretaries. And you can only appoint them from this category of people. People qualified to be elected as members, which is the exact language in 186.1. And so 1033 does not in any way qualify 186.1 except in relation to numbers. You agree?
Yes, Your Honor, but the reason why I refer to the provisions together, Your Honor, as 1033, 186, 186.1, Your Honor. Because, Your Honor, in 1033, the understanding of the Code of Appeal in repeated cases have been...
Yeah, I've heard what you said. I don't you don't need to repeat what you said before. I was just trying to discover in 1033 whether there was something that I missed. But if you agree the language mirrors 186.1, then I have heard your argument on 232. I've heard it. Thank you.
But Your Honor, in 186.1, we submitted, Your Honor, that there are 2 categories.
Yes, I understand that.
Mr. Ford, the problem is that I am having is that if for some purposes you regard unextracted members on the list as elected members and therefore subject them to particular disqualifications or some function, it means that you treat them as elected members for some purposes and you don't treat them as elected members for some other purposes. What is the basis on which we say, well, for this purpose, we treat them as elected members, but for this other purpose, we don't treat them as elected members? Because clearly you acknowledge that they don't vote, they don't have any immunities, they don't take the oath. So for the most important purposes, we don't treat them as elected members. But for this particular purpose that deals with this case, you want us to treat them as elected members. And we still have not gotten the rationale for that.
Your Honor, I don't, if you could just give me one last chance, Your Honor, to repeat it, Your Honor. Your Honor, it is in our respectful submission, Your Honor, an issue that goes to the core of the system and the peculiar system that we have of proportional representation. This issue would never have arisen in Trinidad, Barbados, or any other one that has the first past the post system. Once you're elected, at the end of the constituency election, you're declared by the returning officer, you move down the line. In this situation, because it is a proportional representation system, and because it is representative, will be able to identify every person that he thinks separate and apart from the choice, any specific choice of the electorate. It is our contention that therein lies the issue. If you want to, so they cannot be numerous instances. I would hazard a
Just
guess.
one instance
You know,
where the list
yes,
representative
and
is barred from
you want it
using
is
a person who is
in,
unextracted.
it is intended, Your Honor, to create and to preserve a situation where the list representative does not and cannot be said to have elected the person to the National Assembly. In all the other categories, Your Honor, by virtue of the fact that you have to be extracted, you have to take the oath, there's no way, Your Honor, that that broad definition in which the Constitution says, unless the context otherwise requires, can it fit in just to a situation where you will have such a result, Your Honor?
Okay. All right, you are out of time. Is there anything pressing that you need to add to your submissions?
So,
No?
no, please.
I see, okay. Well, thank you for your submissions. We will take a break now for about 10 to 15 minutes at most, and then when we come back, we'll hear counsel for the second respondents.
All right.
Trump, you ready for us?
Yes, Your Honor. Your Honor, there is on record an affidavit from the Clerk of the National Assembly, Mr. Isaac, at page 411 and 412 of the record, and paragraphs 6 and 7 respectively. He identifies a parliamentary secretary who sat in the 9th Parliament that was drawn from the PPP's list of candidates. And at paragraph 7, page 412 of the record, he identifies a parliamentary secretary, Joseph Hamilton, who was not drawn from the list of candidates. There was a question earlier about what is the practice in Parliament. Now, Your Honours, I may need just about 10 minutes. The argument being raised by Mr. Ford is that, in simple terms, is that if you're on the list, you're elected. And if you're elected, you're disqualified, not from being appointed to, but from sitting in the assembly. And that is the position he expresses at paragraph 57 of his submissions, page 1186 of the record. Now, our submission is that nothing in Article 186.3 says that a parliamentary secretary drawn from a list cannot sit or vote in the National Assembly. And this is so regardless of the characterization of the person drawn from the list as elected or non-elected. Now, Mr. Ford has said that there are two distinct categories created by Article 186.1. In our submission, these categories are not necessarily distinct. The Chief Justice questioned whether the appellants could belong to both categories, and Your Honours will see that at pages 310 and 311 of the record. In our submission, an elected member, howsoever defined, must belong to both categories. A person must be qualified to be elected before they can be elected. Now, Article 186.3 does not create an exception to Article 186.1, nor does it narrow the pool of eligible persons created by Article 186.1. In our submission, 186.3 was meant to make it clear that a parliamentary secretary per se does not enjoy a right to vote in the assembly. The provision is clear that if a parliamentary secretary is not elected at the time of his appointment, he shall be a non-voting member of the assembly. But the provision does not directly address the position of a parliamentary secretary who was elected at the time of his appointment, because such a parliamentary secretary would naturally be entitled to vote in the assembly. So the voting restriction created by 186.3 does not apply to a parliamentary secretary who later becomes a voting member of the assembly, but such a parliamentary secretary cannot be prevented from voting. And Your Honours, the most significant incidence of membership in the assembly is the right to vote in our submission. And what 186.3 does, it makes it clear that in the case of parliamentary secretaries, membership in the assembly does not confer a right to vote unless the parliamentary secretary is or becomes a voting member of the assembly. Now, in the Moran decision, Chief Justice Chang relied on Article 163A, Roman numeral 5, to support his interpretation of elected members of the assembly. Now, that provision, Article 163, is an enabling provision. It says that Parliament may make provision for certain matters which are listed. Now, the words in that subparagraph, Roman numeral 5, who have been elected, were held by Justice Chang, Chief Justice Chang, to imply that extraction follows after the election of candidates. And by further implication, Chief Justice Chang determined that the elected candidates are those on the list. And you'll see that it's on your screen at this paragraph 9 of the judgment. Now, Article 163AV, which is what the Chief Justice Chang relied on, speaks of two things. It speaks of extraction and it speaks of declaration. I'll ask Mr. Motilal to please display that provision on the screen. Now, one follows from the other, Your Honors. Extraction takes place first, and the extracted names are those that are later declared. It's 163AV. Now, on a proper reading of that provision, the extracted individuals are elected by or through extraction and are then declared to have been elected. Now, the reference to candidates who have been elected in that provision relates to the earlier act of extraction. And to say that the words, those words, are a reference to the list of candidates is an interpretation too far removed from the substance of that subparagraph. So, in our submission, the declaration of names, of the names of those who have been elected, is meant to confirm those names that have been extracted. Now, Article 163, 5, was given effect to and meaning through Section 98 of the Representation of the People Act. The Constitution authorized Parliament to enact this legislation. And under that section, Your Honors will see that extraction is done by the list representative and the declaration is done by the Chief Election Officer. Now that, in our submission, emphasizes the separate nature of these two acts of extraction and declaration. So the last sentence in 98, in Section 98, should read that the Chief Election Officer shall declare such names being the extracted names, to be the candidates who have been elected. And that is consistent with Article 163A, Roman numeral 5. The final point we wish to make, Your Honor, is that even if Articles 62 and 162, which are the two provisions referred to in the definition section at Article 232, are saying that every person on the list is an elected member of the Assembly. There are numerous instances where the Constitution itself did not use the term in that sense, and the Court of Appeal recognized this, but chose to follow Moyen. The definition in Section 232, which Mr. Ford relies on, was therefore not meant to be exhaustive. And one approach to take in such circumstances is to ascertain the meaning which best fits the context of Article 186 and which is consistent with the intent or the intention of that provision. Because there is nothing in Article 62 or 162 or even 161 to support an interpretation that an elected member is every person mentioned on the list of candidates. Justice Chan came to that conclusion by referring to 163 AV, which is not even referenced in the definition section at 232. And in our submission, he misconstrued that provision, because the reference to elected members in that provision was a reference to the candidates who were extracted. Unless there's anything else around this.
Okay, thank you. Thank you very much.
Obliged.
Mr. Mendez?
Submission on the proper interpretation of 163 Roman numeral 5 in answer 3A5, and I won't repeat what he said, but just one point in relation to my learned friend Mr. Roysdale's submission concerning the impact of an interpretation of the phrase elected member of the assembly, which did not include everyone on the list. And he was saying that that would therefore preclude the president from appointing ministers before extraction. Respectfully, that is not so. First of all, too much can be made of that, because if the president has been declared elected, then it would not be too long before persons would be extracted from the list in any event, because the election will have been determined already by the appointment of by the announcement of the election of the president. But in any event, section 103(2) of the Constitution, which deals with the appointment of ministers and vice presidents, says that subject to the provision of 101(1), vice presidents and other ministers shall be appointed by the president from among persons who are elected members of the assembly, which if it's before extraction would not include persons extracted, but it says, or subject to subparagraph 7 of 3A of 60, which would ordinarily not apply, are qualified to be elected as such members. So before extraction, you will have persons who are qualified to be elected, and therefore before extraction, you can appoint ministers. Later on, of course, it may happen that those very ministers are persons who are extracted, so they become elected members of the assembly, and then appropriate adjustments could be made. So that that being the only deleterious effect of the interpretation which we advocate, respectfully submit that there is an obvious solution to it under the Constitution. That is all I wanted to say in reply.
Mm-hmm. Okay.
Unless there's anything further I can assist you with, Your Honor.
Yeah, thank you very much, Mr. Mendez. So that concludes the oral submissions in this matter. We will reserve our decision, and we will let you know. It would more than likely be in the new term, which begins in October. So we'll let you know, hopefully as soon as possible in the new term, we would be able to give a decision.
All right.